Hello and welcome to the big picture. The higher judiciary in the country is going through a period of crisis. While some of the judgments have come under question, the crisis which it faces now are the questions raised against the judges and former judges. The recent instances where their behavior has come under question has put the Supreme Court in a dilemma. The Vishaka guidelines formulated by the Apex Court itself and the delay in its implementation has caused problems in dealing with situations it faces now. The Apex Court has now said that it will decide on permanent mechanism to deal with cases of sexual harassment. The issue is no doubt very sensitive and the Delhi High Court has put certain restraints in reporting charges against an ex-judge of the Supreme Court. However, the larger issue of the crisis and the dilemmas faced by the higher judiciary in relation to the recent charges in terms of dealing with them needs a debate. Today we will look at all these larger issues and what are the options before the Supreme Court in dealing with them, including what kind of mechanisms are possible. To discuss this, I have with me Justice B.A. Khan, former Chief Justice of the Jammu and Kashmir High Court, K.N. Bhat, Senior Advocate in the Supreme Court, Shilpi, Jain, a Supreme Court lawyer, and Satya, Prakash, Legal Editor, Hindustan Times. Welcome to all of you. Justice Khan, permanent mechanism to deal with cases of sexual harassment in judicial bodies. This has come up only now, or 1997 Vishaka guidelines, all these years it was overlooked. Now when they start looking at this issue, do they have anything new to fall back on these recent instances, these recent allegations? How do you think the Supreme Court should go about setting up this permanent mechanism?
I don't know. That's for the Supreme Court to see how it should go about it. But as far as mechanisms are concerned, there is no dearth of mechanisms in looking into the complaints against the judges in the higher judiciary. If you start right from the Judges Enquiry Act and then go on to the Judges Standards and Accountability Bill and then go to their own code, which Justice Verma framed, which is a part of the Judicial Standards Accountability Bill. See, all these mechanisms work only and work very effectively in judiciary. May I tell you, see, we have a zero tolerance for any complaint or be that of misconduct or misbehavior or corruption or whatever.
On paper?
Not on paper. Not on paper. In reality.
In reality.
In reality. Show me in all these years, see, we are faced with a dilemma of protecting independence of the judiciary,
right,
and at the same time the attacks against the independence of the judiciary, which are sought to be made, and tirades, the campaigns. See, we are discharging a function in which we can't please everybody. Judges can't please everybody. Certainly. They become vulnerable to different types of intrigues, to different types of plots being made on them, to different kinds of complaints. Most of these are frivolous. In our own judicial fraternity, we say that there is a cottage industry of complaints against the judges. And if you see the nature of those complaints, most of them are frivolous. Any disgruntled person can lodge a complaint against the judge and have him incapacitated or disabled. Now, question is, why on earth should you bring down an institution which still enjoys a credibility, some kind of a credibility in this country? And why on earth a basic feature of the Constitution which provides for the independence of judiciary should be violated on flimsy and frivolous allegations?
No, the last thing you said, why do you say that?
What?
That, bringing down the...
Because this is straightaway damaging the credibility of the institution. What moral authority a judge is having after you make all sorts of accusations against him and then give some kind of a sanctity to it by saying that yes, without any enquiries, without anything. So no, this, if it is damaging the credibility of the institution, it is bringing down this great institution brick by brick, and it is going to have a disastrous impact on our rule of law, on our democratic functioning, on our constitution operation.
Mr. Bhat, let us, whatever Justice Khan is saying, we will accept that, and it has to be accepted. But the fact of the matter is that when serious complaints come against how to deal with it. The simple, I think, breaking down all other things now, the dilemma, the crisis faced, how do you deal with such complaints? Isn't that the basic issue at this point of time?
Yeah, that's what the Supreme Court is going to do.
Right.
They started it with yesterday's order. Because until now, after the Vishaka judgment in 1997, Supreme Court rightly felt probably that there will be no need to set up a machinery to inquire into allegations against judges.
Why do you say rightly so?
Rightly because they never expected such a thing to come. Because there are always certain strata of people who we keep them out of purview of any of these allegations. So it is
want to keep out of it. Hope that
that's what they were hoping to do.
Yes.
That one. And therefore, there was no machinery done. For example, there is a machinery for lawyers and employees of the Supreme Court.
Right.
But there is none for the judges as such, which now they are supposedly trying to do. And then there is another act which has come into force on 23rd of December.
Right.
That is the prevention of harassment of women at the workplaces.
Right.
That particular thing that has come into force.
The question now being asked is whether such laws should be applicable to the judges also.
It will be, because probably I had a glance of it, very probably, because even the employer, workplace, etc. definition fits into that one. Now probably the judges by yesterday's, what they started beginning yesterday, they want to set up a machinery. The idea is there is an in-house, because mind you, this is not to bypass the ordinary criminal law system. This is not to...
No, that itself is... There is a debate about that. There is a question being raised whether the ordinary criminal law justice system should apply to the higher court judges.
It will. If somebody makes a complaint, it is bound to be inquired. It has all been decided way back in the case of the Madras High Court Chief Justice of Veeraswamy's case. And it has been said, now there is no problem about you make a complaint, you can inquire into. There are certain formalities, but they are not above law. This is only, now for example, in the case of Justice Swatantra Kumar, an event supposed to have happened in 2011 is now coming up. The defense is there was no mechanism. There was no machinery to inquire into.
There are two questions on that. One is the delay in filing the complaint. The reply to that is there was no mechanism.
Delay is not in the technical sense. You see, ultimately, if there is any action of somebody, reaction has to be within a reasonable time.
Right.
You can't keep it for 2 years or 3 years. As Justice Khan said, the judiciary is dealing with innumerable sensitive issues. And during that time, they are likely to offend or hurt somebody's feelings, ego, call it anything. All those things are likely to happen. They have no defense. Somebody coming up and after 2 years or 3 years, coming up and says, oh, somebody came and did me so and so things which cannot be proved under any circumstance. But allegations are hurled. If there is a mechanism, one more minute. If there is supposed to be if there is a mechanism which says that unless it is given within 15 days or within 1 month or something, no complaint shall be entertainable, etc., then it loses its base.
Right.
There is some partial protection.
Right.
That is the purpose.
Okay, Shilpi, coming to you. All these years, 1997 Vishaka, till now 16 years, nothing happened. Were there no such incidents happening in the judiciary? Were there no such problems happening for the interns? Were there no such complaints happening? All these, how was it dealt with all these years? And why has it become such a, why has it come to such a pass now?
Well, I never heard of any such incident in the past. I've been in the profession for 25 years now. These two incidents are the first of its kind. And these also got as much spotlight as they got because now we have 24/7 channels who are giving one side of the story. And what is happening is we are having media trials. both the cases, whether it's Justice Ganguly, whether it's Justice Swatantra Kumar, I think they are looking, as far as the media trials are concerned, only the moral issue. If you look at the legal issue, neither of the complainants have gone to the police. As far as criminal justice system is concerned, that requires the basic it requires to set into motion is an FIR.
One second.
And there is a provision.
Let us not get into the merits of both the cases. We will not discuss the merits.
But we will have to discuss the merits if
there is a stay order, and let us not discuss the merits. But the point you are making is fine. Is that so exactly what? So we'll come back to what Mr. Bhat says, that there has to be certain mechanisms, certain parameters which have to be drawn up when these things will not come up. But my question is, all these years, how were they being dealt with?
No, that's what I'm
So
saying.
there were no complaints at all.
Nor is expected to be such complaint.
I have not heard of them, and even in these cases, if you see, you have to talk of them in the legal context.
Okay, in the legal context, what is the
With
point?
regard to Justice Swatantra Kumar, if you see the affidavit of the girl, it doesn't appear like it is being written by a law intern. It's a total lawyer's language.
Shilpi, let us
She
not,
says
please. No, Shilpi, let us not get into the details, because it will be unfair, because the girl doesn't have. We will not be able to. She will not be able to defend herself on those things. We will keep that aside. But I am on the larger issue.
Now about the mechanism.
Yeah, what kind of a mechanism needs to be put in place, or what is possible?
You see, a mechanism can work only as a preventive measure, and I don't see how a Supreme Court judge and a lawyer can be in a relationship like at a workplace. It's an employer and employee. We cannot bring it in the same, according to me, bracket or in the same ambit. In case of an employer, of course, we have a committee which could be, but in case of a Supreme Court judge who's going to be forming a committee who is going to be judging the judges, one is that. And the mechanism can be only something which can be of a preventive kind. Once an offence has taken place, then it is only the police, and under IPC, the amended 354, the law which has come in April 2013, 354A, IPC now deals specifically with sexual harassment. So we don't even have to go to sexual harassment at workplace, because that is again toothless, which is the now act which has got enacted. But 354A specifically deals with sexually colored remarks or whatever these allegations
Even outside
are.
the workplace.
Yes.
Any kind.
Even outside the workplace.
Yes.
Outside the workplace.
Yes.
It's a penal offence under IPC. So why should we go here and there? And a retired judge ceases to be anything. He's a private citizen now.
The problem is with the retired judge. Actually, we'll come back to that. Satya Prakash, before that, let me come to you. A credible and fair mechanism is what is being sought to be put in place. You think that in these kind of circumstances, such kind of a mechanism, in the context of what Shilpi also is saying, how do you think that will evolve now?
In fact, the entire crisis which you initially explained, part of it, the Supreme Court is to be blamed.
Yeah.
Why? Because 1997 they issued Visakha guidelines, and since then there was no committee in the Supreme Court itself.
Yes.
So now, in terms of the new law, they have formed a committee, but that would apply to employees and advocates and all. Second is, as the society progresses and the moral standard, it seems it's getting it's coming down, and
We'll say moral standards changing. Let us not say whether it's coming down or
changing,
going up.
because
Yes.
there was, as Mr. Bhat said, nobody could have imagined
Yes.
that this kind of allegation would be leveled against a judge, and probably the Supreme Court rightly did not have this kind of mechanism, because nobody could imagine that a judge would face this kind of allegation. So that's why I said it's a kind of degradation of moral standards. So having said that, the Supreme Court, first, they didn't have a committee. Second, this the entire society, it's a different society. But third, the first time they faced this kind of problem, they didn't have the sense of balance in dealing with the issue.
Exactly.
And they were in a kind of haste, and they became slightly
There
defensive.
was some kind of a knee-jerk reaction.
Knee-jerk. Yeah. They were in a haste. They were slightly on the defensive, diffident, and knee-jerk reaction. And all of a sudden, they did something which does not have any precedent.
That is, let me get. I know
Just
what
one
you're
second.
talking about.
No, I'm not naming anybody.
No.
But what they did,
Yes.
it has led to this kind of situation. Had
Absolutely.
they acted in a much more mature fashion, and I'm emphasizing this,
Yes.
or much more, with much more detailed discussion, and they could have come out with something which was not this kind of.
Exactly that. Justice Khan, this is the question. The question is, in the case of, I suppose we can name this incident, because Justice Ganguly's case, the Supreme Court went ahead and appointed a committee and did all that, and now they're saying that we will not do it anymore. In December, they came out with this thing saying that we will not anymore take up this kind of cases against ex judges.
Add to what you
Yes.
said, because what they did was completely contradictory. They said
Exactly.
we do not have jurisdiction. Like the judge is a former judge, the intern is a former intern,
That is
and
where
still they went on to
Exactly,
say
sir.
something. This would have simply said,
don't you think
you just go to the police and lodge an FIR.
Justice Khan, that is where the problem started. In
No,
dealing
you
with-
yourself answered that. You yourself described it as a knee-jerk.
So you agree it was a knee-jerk reaction, which could have been handled
It
differently.
was, but there were certain circumstances at that time, because the reports which appeared in the media said yes, judges recently, then that recently created a problem. Maybe there may be some sitting judges also. And then Chief Justice in his wisdom thought that we must best inquire, maybe who is this. So maybe there was a circumstance. I am not justifying, nor am I making a distinction between this and that, and their post stand that after retirement we can't deal with, which is a correct legal stand. See, once a judge retires, he is out of the hands of the administrative.
So he
court.
should come under the normal criminal judicial process.
Depends.
Again, you say
unless
depends.
I am for even providing a protection, and even
Post-retirement.
post-retirement insulation should be there, because you create so many enemies in the process of your functioning. If you leave this man to wolves, if you leave him to wolves after his retirement and make him to go from police station to police station, then what independence of judiciary are you ensuring? Then he better not pass judgments against the high and mighty.
That's an
This
important point to make.
an assertive judge is facing different types of lobbies. He is
Okay.
creating different types of enemies.
Your point fully
Please,
well taken,
please
sir.
provide him a protection till he dies.
Okay. Mr. Bhat, the problem is with the retired judges. Actually, when we boil down to the whole thing, now also, this mechanism which the Supreme Court is talking about needs to deal with the issue of retired judges. Because sitting judges apparently will come under these Vishaka guidelines or whatever they are going to formulate. So the retired judges thing. Justice Khan has now come out with this formulation that even retired judges needs to have some kind of a protection.
Probably, I suppose the better to wait for another month or so, because now there is Supreme Court has already issued notice to several interested parties and appointed two eminent lawyers, Mr. Nariman and Mr. Venugopal, to assist, to come out with a plausible arrangement which doesn't take away the judicial independence, that protection, and at the same time,
Make sure
if
that
there is a real victim of certain this one, they also get a remedy. You see, you may recall that in the United States, it's nothing new, because before Clarence Thomas was appointed, his secretary came and gave evidence before the committee of this judicial Senate committee.
Senate committee.
For about 13 hours,
Yes.
giving details of the misbehavior of judge, but of course the committee overruled it and he was appointed. That is different. 20 years later, New York Times wrote an editorial that this is a legacy worth remembering. Because of our boldness, more and more people come, and there are more and more committees or mechanisms provided in the United States for the workplaces or elsewhere, even in the community, for sort out these matters. So the more and more people are coming out, and apparently the incidence of harassment in the workplaces has come down. And I also hope that now we are dealing with a small section of the people, but important section.
Yes.
Both High Court and Supreme Court judges who have retired. And they are, it's a very delicate issue, We can't just across the table say that this should be or something. But what is needed is a particular, some acceptable mechanism should be there, so that anybody, if an intern feels aggrieved, can go and give a complaint right then and there now. Because somebody wants to take it to the court and all, that is up to them. That nobody can prevent. But otherwise, if there is a solution is needed, they will decide during that time whether that is worthwhile, whatever it is. I mean,
I think Shilpi, don't you? I mean, what Bhat says that one, there should be a mechanism. If there was a mechanism in the case of both these interns, it wouldn't have reached this kind of stage. Maybe we wouldn't have had this kind of media trial. Maybe we wouldn't have had those people to come out in the open on a blog or things like that. Don't you think that the problem was that there was no mechanism where these interns could have approached? You don't think so?
You see, I am still wondering what kind of mechanism we can have, who will judge the judges. That is my only issue. And of course, we will know soon.
They themselves like the Vishaka guideline says that in a normal workplace, you have to set up a committee of, internal committee, like every other organization is now setting up an internal committee. That in those internal committees could at least work as a bulwark against this kind of
now, sorry to interrupt her. That's look, one of the things which I just going through the various, because this problem is worldwide.
Exactly.
There is nothing specific about India or nothing specific about, because one of the things like what is eminently suitable for a civil litigation type of thing, a mediation. I believe there are mediators who have been able to go and just ask the victim, what is your complaint?
Right.
And come and tell this particular thing. If it is not extremely serious, don't blow it beyond, so that it doesn't happen again. That is the idea about it. I believe highly successful.
If you actually read the mechanism which the Act talks about, it says...
Which act are you talking about?
Sexual harassment. Which has now replaced the Vishaka guidelines.
Right.
And it gives elaborate details of the mechanism. It is more specific to the employer that, they'll deduct the salary of the employee in case of... Now, that doesn't apply in this case.
The ultimate thing is to dismiss him from service.
Yes, and all that. That doesn't apply here.
Yeah, exactly.
Now, to have a parallel investigation agency, that is always full of danger and it will set a wrong trend. That should be left to the police. No, that in any case can't be. It's a toothless kind of...
Leaving it to the police. Are you trying to suggest that so High Court judges, Supreme Court,
in the
police...
case of an employer-employee, you see there are the terms and conditions there. You will deduct his salary. You will throw him out of the job. Now, in case
all that will not apply here. Then
yes.
I agree.
So what could be the outcome here of that, I'm saying, of this commission that you are talking about,
or that
mechanism,
if
it doesn't lead to filing a police complaint, like, okay, these interns, you say it will solve the problem. Had there been a mechanism in place, how it would have solved the problem, I'm still wondering.
Okay.
In case of...
Justice Khan?
As already... I have already said, judge is a very vulnerable...
No, one thing, are we clear here that, these kind of, whether it's sitting judges, first of all, do we differentiate between sitting judge and retired judge?
Of course we'll have to.
No, we will have to, but at the same time, we'll have to take care.
We have to make a distinction between sitting judge and
the sitting judge has an additional constitutional protection.
Yes.
Which retired judge doesn't enjoy.
But at the same time, a retired judge has to be protected for the actions he has taken as a sitting judge, which invite reactions for quite some time after his retirement.
How does one determine that a complaint against a retired judge is born out of some problem coming out of the judgment, or it was it may be a genuine complaint.
An honest and sincere inquiry will lead you to that conclusion, even a prima facie inquiry to that conclusion.
And then leave it to
the conclusion. That's what I'm wondering.
She asked, what will be the conclusion?
Of what?
Could be?
No.
Of that mechanism.
One question is...
Then what could be the conclusion of that mechanism? Her dilemma, her question is this. what could be the conclusion of such a mechanism? That let us assume that the mechanism
Is
comes-
already there.
Okay. No, mechanism is
No,
there.
no,
The
no.
mechanism comes to the conclusion that this retired judge was indeed guilty of having committed some
Like
wrong.
they have already
just
held
a
that
minute.
prima
Mechanism
facie
is,
case is made out.
Made out.
No, they did not say
Mechanism
prima
is
facie
not
case.
The
only.
first one said.
In the first case.
No.
First
Even in
committee said-
Ganguly's case, Justice Ganguly's case, what they said, there appears to be that this lady's complaint, whatever it is, if it is accepted, would amount to improper conduct. It is a very
vague.
very vaguely
That
worded
is
as
what
it
a
could be.
mechanism can. How far?
No, no.
Can it go farther than that?
No,
Sir,
if it is a-
mechanism,
yes,
see,
if it is a-
mechanism is not only you set up a committee and that committee will inquire and all that stuff. Mechanism also includes some parameters, some regulations,
Yes.
some methods for action. For example, take a retired man. There might be a regulation that in case something is proved against him, then this consequence of his will, curtailment in pension will result, something will result. So, mechanism, when we
For
talk
that,
of
there has to
mechanism,
be an
just a minute,
amendment in
just a minute.
It's okay. That law amendment.
When we
is
are
not a
talk of
problem.
mechanism, we talk of
Including amendment.
including a law, just as your sexual harassment act became from this thing, from that.
Which are
See,
considered.
in South Africa, we have
Can
a
judges
complaints
have that
commission.
power?
All I am stressing is that since judiciary's independence has to be protected, which is the constitutional duty, the complaints commission like we have in South Africa, if you are talking of some new mechanisms again and again for everything a judge does, then it has to be by judges only. That complaint
It can't be outside. Yeah.
Yes.
Satya Prakash, quickly.
Well, there are two aspects. One, the independence of judiciary.
Has to be ensured.
Second, if nobody can say that there cannot be for all times to come a judge who will not commit something of this
You're
sort.
right.
So keeping so how to
That
balance
kind
it out
of presumptions are the days of such kind of presumptions are
are
over.
over. So
would you agree, Mr.
Nobody is
Bhat?
a human being.
So I'm saying
I don't think
so
that
you have
anybody
to-
can get a life immunity,
Yes.
but a life protection, yes, but not immunity.
I'm saying so we have to strike a balance between independence of judiciary and providing a mechanism where if there is something of this sort, the aggrieved person can go there and seek redressal. Why?
What happens later?
What happens later, depending upon
Has to
the
depend
gravity
upon
of the gravity.
the normal criminal justice system should operate.
Can
I'm saying-
operate. For example,
It will.
Can
if-
operate,
yes,
should
yes,
operate.
it has.
Yes,
It
of
has.
course.
I think
If Chief Justice of India sanctions a prosecution against a person, it will.
Okay, I think
Justice Nirmal Yadav is facing
Nirmal Yadav is
prosecution.
not.
Yes.
Justice Samit Mukherjee,
Yes.
he faced prosecution.
No, so many judges,
it's not
even
that-
Rajasthan.
If that is to follow.
so. Shilpi, are you now happy with this kind of a situation now?
No,
Where
I
that
was always saying that a normal criminal process
no,
is
normal criminal process, that
has
this
to
mechanism
follow.
and then the
Ju-
normal
just
criminal
as a
That is what
government
I'm saying, the
servant,
mechanism will become
just
a
as a
toothless
government
body in
servant,
that
you
case.
think it will become a toothless body?
Girish,
Not
just
have
as a
to
government
pass
servant
powers.
requires a sanction for prosecution,
Right.
judicial judges must require all the more a sanction from their head, Chief Justice of India, for any kinds of
Yes.
prosecution is not.
Retired judges. The whole
Retired
question
judges
is
also.
retired judges.
It is not barred. Even in case of retired judges, there must be a reference for sanction.
I'm not
I
sure-
plead for
I'm
that.
not sure
I
whether
plead for
retired
that.
judges they
Absolutely.
require
You know, the
protection.
This is a debate. This was a very sensitive debate. I'm sure all my participants also understood the sensitivity of it. But we have tried to open up some issues which could be debated and help the Supreme Court to come to some kind of a conclusion where a credible and fair mechanism could be created, so that at the same time the independence of the judiciary also is upheld. We'll wait and watch how this will emerge in the coming days. Thanks to all my guests, Justice B.A. Khan, K.N. Bhat, Shilpi Jain and Satya Prakash. Please keep watching. We'll come back with another issue on Big Picture same time tomorrow.